Good morning, this is your Kelso Report for Monday, September 24th, and I'm your host, Clark Kelso. We have 4 cases to take a look at today. We deal with the questions of whether global warming can be considered a federal common law public nuisance, whether an inmate's lack of knowledge about an internal grievance process excuses his failure to exhaust administrative remedies, whether a dismissal on purely procedural grounds makes the defendant the prevailing party for purposes of attorney's fees, and finally, whether California law or foreign state law applies to the issue of the liability of a dissolved foreign corporation. Well, when novel facts arise, courts are often faced with the question of deciding whether one or another regime of existing statutory regulation applies, or whether aspects of the common law may apply. The issue has been arising in recent years because of the advent of global warming and what appear to be some of its early consequences. In native village of Kivalina versus ExxonMobil, several cities in Alaska that are now threatened with seawater rise, allegedly as a result of global warming, filed suit against a number of the largest oil and gas producers in the United States, seeking damages on the theory that the defendants' massive greenhouse gas emissions have resulted in global warming. The plaintiffs allege the defendants' activities constitutes a federal common law public nuisance, justifying an award of damages and other appropriate relief. Before the advent of modern statutory environmental regulation, beginning in the 1970s, courts would every now and then entertain a public nuisance claim that really was an invitation to the courts to engage in a broad program of environmental regulation as a matter of common law. Fortunately, I think, statutorily prescribed environmental regulation came just in the nick of time and displaced the common law. Well, consistent with that history, the Ninth Circuit in native village of Kivalina held that the plaintiff's claims were displaced by the Clean Air Act and the Environmental Protection Agency's regulatory actions that the Clean Air Act authorizes. In the context of that pervasive federal regulation, there simply is no room for this type of common law cause of action, and the plaintiff's complaint was dismissed. Next, a prisoner litigation case. As we have seen in cases recently, courts really do go out of their way to help inmates without lawyers through the maze of court processes. But there are limits to everything. In Albino versus Baca, an inmate who complained about the jail's failure to relocate him to protected custody ultimately led to his being attacked and raped by another inmate. He filed an action in federal court protesting the failure to relocate him, but the action was dismissed because he had failed to exhaust his administrative remedies. He claimed that he was unaware of the jail's grievance procedure and therefore did not need to exhaust. Well, a majority panel of the Ninth Circuit disagreed, holding that an inmate's lack of awareness of a correctional institution's grievance procedure does not make the administrative remedy unavailable for purposes of the Prison Litigation Reform Act, unless the inmate meets his or her burden of proving the grievance procedure to be unknowable. Well, the plaintiff in this case did not meet that high burden of proof, so the Ninth Circuit affirmed the district court's grant of summary judgment in favor of the jail. Next, we turn to attorney's fees. Now, again, as we all know and are familiar with, under the so-called American rule, each litigant is generally required to pay his or her own attorney's fees unless one of several exceptions applies. Two of the most important exceptions: if a statute provides for a prevailing party to recover attorney's fees, then a court can award them. Or, if a contractual clause provides for attorney's fees, if the parties have agreed on attorney's fees, then again, courts will enter an attorney's fees award as appropriate. In Candy Kiss of California versus Texellant, the second district had to resolve the question of whether a litigant who prevails in state court only on a procedural ground is nevertheless the prevailing party, even though the same lawsuit may then proceed in federal court. The issue arose when the plaintiff sued the defendant in state court for what amounted to copyright infringement. The defendant successfully had the state court action dismissed on subject matter jurisdiction grounds, since federal courts have exclusive jurisdiction over copyright claims. The plaintiff then refiled its action in federal court, but the defendant wanted to recover the attorney's fees it had incurred in defending the state court action and filed a motion for fees. Well, the second district agreed with the defendant. As it explained, Candy Kiss chose to sue Paramount initially in a state court. Paramount expended resources defending that suit and was able to obtain a complete and final dismissal of the claims against it insofar as any state litigation was concerned. Thus, Paramount achieved complete success in defeating Candy Kiss's state action against it. And in these circumstances, both the contractual provision and Civil Code Section 1717 authorized the recovery of attorney's fees. That Candy Kiss could and ultimately did refile its action in another court does not deprive the California trial court of authority to act in the action finally disposed of before the California court. Defendant gets the attorney's fees. Finally, a case involving a corporate survival issue. The common law was rather hostile to the idea that tort actions could survive the death of the victim. That's why in common law there was no cause of action for wrongful death. Reacting to this gap in the common law, legislatures began about 125 years ago enacting statutes creating wrongful death statutes. Well, a similar problem can arise when a corporation, which is an artificial entity created by statute, dissolves. After the corporation is gone, how can the corporation be sued? State corporate laws have come to different conclusions regarding this question, and the issue arose in Robinson v. SSW, where the California plaintiff, who died from asbestos-related mesothelioma, filed a wrongful death action in 2009 against a Nebraska company that had dissolved in 2002. According to Nebraska law, all suits against a dissolved corporation must be brought within 5 years of the dissolution. Well, the issue for the first district was whether Nebraska law applied, or alternatively, whether California law, which did not have a time limit on suits against dissolved corporations, applied. Analyzing California's corporate law, the first district concluded that a foreign corporation generally does not constitute a corporation for purposes of the relevant California statutes, and that instead the law of the place of incorporation governs the question of corporate survival for purposes of being sued. Accordingly, Nebraska law applied, the 5-year rule, and the plaintiff's tort action, filed 7 years after the dissolution, was properly dismissed, since it was filed several years too late. And that's it for today's Kelso Report. Have a great day in the law.